thank you all for coming. We know there are a lot of other really interesting panels at this time, and we're particularly delighted that you chose our panel, The Duties of Data Loyalty and the Future of Data Protection. I'm the moderator, Neil Richards. I'm a professor at Washington University School of Law in St. Louis, Missouri. And I'm delighted to have on my panel, make sure I get the number right so I don't damn anybody with faint praise, 5 of the world's leading experts on these questions. And what we're going to try and do is everyone is going to talk without slides in a hopefully entertaining way for about 5 minutes. And then we're going to mix it up amongst ourselves. And then at about 5 o'clock, we will open it up to your questions. And we really do want to leave room for that. I know these are famous last words for commentators and moderators at these sorts of events. So let me introduce my panel. Starting at the far end, we have David Erdos, who is the co-director of the Center for Intellectual Property Information Law, CIPL, and professor of law and the Open Society in the Faculty of Law, and a fellow of Trinity Hall, Cambridge. We have Carolina Foglia, who is the head of sector for legal affairs, cooperation, and enforcement at the Secretariat of the European Data Protection Board. We have, who's sitting next to Carolina, we have Orla Lynskey, an associate professor of law at the London School of Economics, who is an expert on data protection, technology regulation, digital rights, and EU law. We have next to Orla, Claudia Haupt, who is an associate professor of law and political science at Northeastern Law School, and Claudia is one of the world's leading experts at the intersection of speech, free expression, technology, and health. And sitting next to me, Woody Hartzog, a professor of law at Boston University, and in full disclosure, my co-author on some of the loyalty and trust work that we're going to be talking about in this session. I will do my best to maintain an illusion of objectivity as I preside things. So let me start by kicking things off with a few opening remarks. So we don't have to tell anybody in this room that we are 5 years into the effective operation, the effective operation is an open question for discussion. We are 5 years into the operation of the General Data Protection Regulation, almost to the day. This year also marks another important anniversary in data protection law. It's the 50th anniversary of the publication of the Fair Information Practices Report by the US government, which formed the foundation for the OECD principles, for the directive, for the GDPR, and for so many other data protection frameworks. Indeed, the notion of data protection itself, though if there are people from HESA here, they will dispute that, but certainly highly influential around the world. At the same time, while this is a time of celebration of the GDPR, unless you are Mark Zuckerberg, I think the one thing that I have noticed in coming to CPDP in particular for the last few years is something of a battle for the soul of the GDPR. And let me say what I mean by this. I think there are a number of people, I'm sure there are a lot of people in this room who believe in good faith and with a lot of evidence to support it, that the GDPR is not just a set of procedural rules designed to harmonize or process data, but a self-contained ethical system, a philosophy grounded in human rights that is not just how you process data, but how you should, how you must process data, and provides a certain level of restriction on processing. On the other hand, there are possibly people in this room, maybe they work for law firms, who know quite well how to take a data protection impact assessment, how to run in-house a legitimate interest balancing under Article 6.1f. And surprisingly, I've not seen data on this, but I would not be surprised if most legitimate interest data protection balancings taken into account by firms for clients or by organizations for themselves tend to find at the margins that there is a legitimate interest in fact. And so you have this struggle, right? Is the GDPR substantive, robust, and constraining? Or is it, if we're being cynical, a recipe for processing data however you want to process it? And that, I think, is a meaningful struggle. Even if I've drawn some polar opposites here, even if you reject the binary nature of this, in the middle, in the margins, in the continuum between those two archetypes, I think there is a push and pull and a struggle. And that's one of the things that we're here to talk about today. The other thing that we're here to talk about today is what else might protect fundamental human rights of data protection and privacy beyond things like lawful bases of processing and rights to an explanation and heightened protections for the processing of sensitive data. Are there other more substantive approaches? And one of those approaches that's in the, this is not a surprise because it's in the title of the panel, is the idea of a duty of loyalty, rather than what could be characterized as at least partly procedural rules about lawfulness, proportionate, necessary processing. Rules that are substantive in terms of, we don't care how you process the data, but we are taking certain kinds of data processing practices, certain kinds of actions, certain kinds of methods off the table entirely. Not for balancing, but actually to remove them the way that we do in other areas of the law in Europe and in the United States and in Britain. I hate that I have to make that third distinction as an Englishman who loves Europe. But in these three jurisdictions, for consumer products, right, you simply cannot sell meat that has maggots in it. You cannot sell children's toys, however cheaply, that tend to break and produce sharp edges. Is there something like that for data? And what we're seeing, whether in Britain from the Information Commissioner's Office, with its age-appropriate design code in California, with its sort of clone of the AADC as part of the California Consumer Privacy Act, or in pending bills that have some chance of success, the idea of a duty of loyalty. So those are our questions. Is what we have with data protection enough? Would a duty of data loyalty be a complement or a complication to effective, meaningful, human rights advancing data protection rules in the United States, in Europe, in Britain, maybe elsewhere in the world? Are there other things that we should think about for the future of data protection, other ways in which we can improve it, either by strengthening it, as I think most of the panelists up here would probably want to see, or by weakening it, by, quote, cutting red tape, and by making it more business-friendly, as the Sunak government in the United Kingdom seems to be trying to accomplish with the UK GDPR. So with that out of the way by way of introduction, I'll turn it to Woody.
Thank you, Neil. That was a great setup. Can everyone hear me okay? I just want to make sure. Okay. So I'm going to kick off our session talking about the concept of loyalty, which is, as Neil mentioned, something that we've been writing about for almost a decade now and that has made its way into various aspects of data protection and privacy law, both in the United States and in the EU. And I'll start with the question of what is loyalty? What do you mean by that word? Because it is not something that pops up a lot in data protection and privacy circles. And it starts with the issue of power asymmetries. Loyalty is all about power asymmetries, which is something that I heard multiple times just this morning in the panels that we went to. They mentioned it about 10 times, that we're all acutely aware of. And the reason why loyalty is important is because an incredible imbalance of power within a relationship creates incredibly strong incentives for the powerful actor to act in ways that are against the interests of the trusting party and advance the interest of the powerful. We call this self-dealing in fiduciary law. This is where the concept of loyalty first originated, though importantly, what we're trying to do with this conversation is pull loyalty out of fiduciary law and see what it can do as a concept for us in other areas, particularly more regulatory areas. At base, loyalty is an obligation to make the interests of the trusted party subservient to the interests of the trusting and vulnerable party. That at base is what we're sort of talking about is the subservience of financial interests. We think it is an ancient but revolutionary idea whose time has come for privacy and data protection law. Why look at data loyalty? Isn't fairness sort of doing the job for us, which is a lot of what we want to get into in this panel, or could there be something more? There are advantages and drawbacks to loyalty that I'll briefly sort of throw out, one of which is if you're going to embrace this concept of data loyalty, in theory, you're talking about a relational protection. Not one that follows the data, which of course the GDPR explicitly follows the data, but one that is bound by particular relationship of trust, where one party willingly becomes vulnerable to the power of another party. And there are disadvantages to that, which of course it's bound by the relationship, but the advantage to that is that it is acutely sensitive to the degree of power disparities. The more vulnerable you are, the greater obligation the powerful party has to act in loyal ways. It doesn't get caught up on harm, which is something that, at least in the United States, often trips up meaningful privacy rules, as there's always this sort of never-ending search for some kind of visceral, emotional, reputational, physical, financial harm. The harm within relationships of trust when one is disloyal is to the integrity of the relationship itself, and this is borne out generally. The third is that loyalty, and this might be a little controversial, but I'd love for us to get into it, is a way for us to finally get past the concept of consent in data protection law. Now, I realize that consent is the thing that is strived to be achieved by many aspects of data protection law, but in my work and in work that Neil and I have done together, I've come to believe that consent is a fundamentally broken regulatory mechanism at scale for data protection. And you can't simply, of course, get rid of it without having an alternative in place. And loyalty is something that Neil and I think could actually protect people no matter what they choose. Whereas we think that consent actually ends up trapping people. So what does loyalty look like, and where can we find it is another aspect. In 1 minute, you can see loyalty in no conflict rules, general obligations of loyalty to avoid acting in ways that conflict with other people's best interest. You can see it in the ADPPA and its duty of loyalty. That's a robust version of data minimization, which looks a little bit like some data protection rules. The ADPPA, oh, that's a good point. In the ADPPA in the United States is the American Data Privacy and Protection Act, the first meaningful bipartisan piece of privacy legislation that's been introduced in quite some time, and it's grounded by a duty of loyalty. It's present in the best interest requirements of the Age-Appropriate Design Code Act, and we also think it implicitly shows up in the Digital Services Act, potentially in the fairness requirement within the GDPR, and we think that loyalty allows people to get behind a more substantive value that explicitly makes a lot of the pathologies that we worry about with data protection subservient, and we think that it elevates not only the individual but collective groups of people, which sometimes I think data protection can get lost in as well. And happy to get into this more later. Thank you.
Claudia.
All right, thank you. Everybody can hear me? Yes? Okay, great. So what I want to do today is very quickly, in 5 minutes, zoom out from Woody's remarks. And so what I'm mostly interested in are the constitutional frameworks around the solutions that we're going to be debating in much more detail on this panel. And one of the reasons that I want to do this is because I believe that we should be debating, as Neil also alluded to in his opening remarks, on the values that are reflected within those frames. And we can only really have a meaningful sort of transatlantic dialogue if we understand sort of the perspective from which we arrive at this discussion of what those underlying values actually are. So I want to understand the constitutional frame in which we're situated. When I say that, I actually mean mostly the United States, the EU, and Germany, because that's the regime that I'm most familiar with, and I think it's also fairly representative for making this point. So the two areas that I'm studying as a matter of sort of getting to the bottom of this are speech and privacy. I think here what I'm particularly interested in right now is sort of thinking about how fundamental rights apply, how we conceptualize the constitutional framework of horizontal as opposed to vertical application of fundamental rights. So the sort of classic liberal model, right, is negative rights against the states as the human rights framework that apply only between the state and the individual. their negative rights against state intervention to protect the freedom of the individual. And because you all are thinking about the things that you're thinking about, you are acutely aware that that is an insufficient way of thinking about human rights. And that is the problem that the U.S. framework is running up against. The other part of it is, well, maybe they don't only apply between the state and the individual, but also to some extent among individuals. So this is the acknowledgement that there are powerful market-dominant actors that also can infringe on individual freedom. And this may go further into legal interactions among individuals. Now, the standard account is that in the U.S. it's all vertical, right? This is known as the state action doctrine, which is not entirely accurate. I'll give you the standard account, even if it's a little bit of a caricature. So there are some sort of like breakthroughs through the state action doctrine historically, even in such areas as free speech jurisprudence. But just because I only have 5 minutes, I'll give you the standard account. So U.S. is all vertical. The EU, Germany specifically, also significantly horizontal application. The comparative constitutional law literature generally puts Ireland as sort of the most horizontal application model. And even, this is, just a reminder that even within the EU, we're dealing with a number of different constitutional mechanisms, which of course, in U.S. discourse, and I teach at an American law school, so I think I'm allowed to say this, it just sort of gets glossed over, right? Europe is the thing that they do over there, and so that's sort of like, all the same when it's really not. Okay, so acknowledging that we have different ways of looking at these interactions, what does that mean for speech and privacy? So for those of you who also follow the exciting world of content moderation, you may have come across recent social media laws in Florida and in Texas that try to prohibit social media platforms from deplatforming their users. Because of what I just said, because there's no horizontal application, they have to come up with creative solutions. They try to get there through this idea of platforms being common carriers, and you can't just get kicked off. So we don't run into this problem elsewhere. Contrast that, for example, with the German Federal Court of Justice decision regarding deplatformings on Facebook, where you have free speech. I was almost going to say First Amendment, where you have free speech rights on both the users and the platform side. Now, I'm going to use a little shortcut to talk about the privacy situation. I'm just going to quote what Woody and Neil have written in a paper recently, which is European privacy law, as you all know, is built on a foundation of fundamental human rights that are protected against both governments and private actors. American privacy law is not. And so, for example, GDPR is best understood, I'm still quoting them, by the way, which is very odd sitting next to them. The GDPR is best understood as a vindication of fundamental human rights in privacy and data protection against other members of society. So you have this underlying fundamental right perspective. You have this operationalization among members of society, but that is all absent in the American context. And from there, the jump to private law workarounds looks pretty appealing. Right, and so just focusing on the privacy component that Woody just mentioned, particularly the duty of loyalty is appealing because it avoids both the First Amendment constraints because of the absence of a public law framework, right, and it potentially creates new accountability mechanisms like the idea of information fiduciaries, and now more targeted, as Woody and Neil suggest, in the duty of loyalty. And so the next question then is, well, on the one hand, right, there might be a different constitutional mechanism to directly enforce individual rights against private actors, which takes us back to the beginning and the doctrine of horizontal effect. There also just may be beneficial reasons to think about a duty of loyalty, even in regimes that do have horizontal application. So this may be sort of a two-pronged way of getting at a shared underlying problem. And that gets us to the step where we can then actually talk about the values that we're trying to get at with these different proposals that are floating around. Did I stay under 5 minutes?
Admirably kept to 5 minutes.
Thank you.
Orla.
Hi, good afternoon, everyone. So I think this will follow on from what Claudia was just saying. So in preparing comments for today, I went back to Neil and Woody's work on data loyalty, and in particular their paper on legislating for data loyalty. And that starts by saying that American privacy law is in a rut, that it's kind of missing its soul. And in part, the explanation for this is because there's been a lot of focus on the notions of notice and consent, and that there is a clear kind of mismatch between those notions and the kind of power of big tech and the data processing capacities that we see now in modern societies. And so in that sense, data loyalty could be what kind of gets US privacy law out of that rut. But I guess my starting point for today is if EU data protection law is in a rut, it's not the same rut. And so data loyalty might not be the solution. In this sense, it could be a US solution to a US problem. And I don't mean that in any kind of derogatory way. I mean that in the sense that, regulatory experimentation, I think, to achieve the same outcomes is extremely welcome here. In particular, because in privacy law, I think we have a lot of privacy path dependencies, which are kind of an externality of the international data flow regimes that we could maybe talk about. But I was thinking about to what extent could we achieve the same outcomes, the same benefits of data loyalty in the EU framework, but using a different normative anchor, that normative anchor of fundamental rights. And so in looking at the definitions of data loyalty that are in their papers and also provided today, I think you see kind of two kind of key benefits of the idea of data loyalty. So one is that it's relational. It kind of shifts to fit the mold of the particular relationship of data processing that is occurring at a particular point in time. And the other one that I thought was quite interesting, which is mentioned in some of the work, is that it can expand to cover harms or negative effects that we might traditionally find difficult to kind of shoehorn into data protection and privacy laws. And so in thinking then about how might EU law kind of achieve these same benefits but in a different way, I think the answer here lies in placing increased emphasis on the principles that you find in Article 5 of the GDPR. So those kind of fair information practice principles. And so for anybody who attended Felix Speaker's lunchtime talk, he speaks about this in terms of providing kind of structural, there are the elements of data protection law that provide structural protection as opposed to individualized protection. And so key principles here, I know Carolina is going to talk more about fairness, but we could also see things like purpose limitation, where we've seen its kind of use or underuse so far. And I think that could be important in ways that are significantly underdeveloped. So people think of purpose limitation as simply preventing data processing for incompatible purposes. But it also requires us to only engage in data processing for specific purposes. And data protection authorities haven't been so hot so far on enforcing that. So if you look, for example, at some of the reasons why big tech organizations can internally share a lot of data, so kind of first-party data sharing, which is treated somehow differently to third-party data sharing, I think we could, locate a lot of that problem and that kind of difference between first and third-party data sharing in the absence of enforcement of something like purpose specification. But let me provide, I guess, two kind of more specific examples. So if we're thinking about the ways in which data protection law, EU data protection law, can be attentive to power imbalances or power asymmetries, first of all, it can do this through the notion of consent. So we've kind of nuanced the notion of consent, I think, a bit more in order to be attentive to power imbalances. So You take, for example, the Meta case that is pending before the Court of Justice of the EU, where the question is whether or not consent to a dominant digital platform could ever be valid. And you see in the opinion of the Advocate General, we're still waiting for the court's judgment, that the dominant position of a company is a factor in considering whether or not consent is valid. And what is, I think, really interesting there is that the Advocate General specifies that dominance here doesn't have to be equated to kind of competition law dominance. We could be thinking here about other forms of power asymmetries. So the last panel in this room was talking about vulnerabilities, and Malavika Raghavan had mentioned various forms of vulnerabilities that might be, for example, based on situational power imbalances or relational power imbalances. So I think that opens us up to consider a lot more power asymmetries within the data protection framework as we have it in the EU. Equally, you look to something like recent European Data Protection Board decisions. So again, there's a theme, those against Meta. You see that, for example, in decision 03 of 2022, for those of you who are nerdy like me, in paragraph 222, the Data Protection Board says that the principle of fairness recognises not simply the reasonable expectations of individuals, but is also attentive or has regard to the relationship and potential effects of imbalance between the data controller and the data subject. So we're explicitly bringing these power imbalances into the fold in data protection law through principles like fairness as well as through mechanisms like consent. I think where this gets more controversial is when we think about the ability of data protection law to deal with or tackle kind of harms or issues that are kind of broader than your typical privacy harms, let's say. So scholars like Jeff Ausluis, or more recently in her recently defended PhD thesis, Florence Dat, argue that data protection law provides a tool to deal not simply with privacy harms, but also to deal with any kind of harm to fundamental rights. And thinking specifically about how you could consider harms to fundamental rights like discrimination or freedom of religion or other things through data protection law, Jeff Ausluis, for example, argues that something like the requirement of lawful data processing doesn't simply mean kind of internal legality within the GDPR, but means lawful as in compliant with any aspect of the legal framework, including other fundamental rights. Here, I think what is interesting, so I think this poses two questions that I don't have answers for. So first of all, to what extent is the use of the GDPR or data protection in this way as a kind of a multifunctional tool to protect fundamental rights generally? To what extent is that legitimate? And in Florence's work, we had a discussion about how you distinguish here between a legitimate use of the GDPR to protect other fundamental rights and something that might even be classified as an abuse of rights or an abuse of the legislative instrument. And then to what extent does this raise issues around the capacity of data protection regulators to deal with this within a single regulatory framework? And then finally, maybe just to tie back to what Neil said at the beginning, if we place more emphasis on these Article 5 legal principles, thinking that they give us kind of more structural protection and so could achieve some of the same ends as a duty of data loyalty, then I think in some ways the principles here are empty vessels that can be filled as a data protection regulator or as a court so desires. And in the EU, we tend to fill those principles by reference to the EU Charter of Fundamental Rights. In the US, you could potentially fill those principles by reference to data loyalty, but this, of course, also has risks. And so if I think about the EU context, if you look at the Article 5 principles, they all contain references to the notion of necessity. And so Spiros Sarakis is here, one of our PhD students at the LSE who's working on proportionality in data protection law. But you can see that the work that the principle or the notion of necessity will do is extremely significant insofar as if you look, for example, at recent decisional practice across the EU about the necessity of facial recognition technology for authentication and security purposes, in the Netherlands, there's been some decisional practice to suggest it should only be used in really serious circumstances, like for access to nuclear power plants. In the UK, we consider it necessary for school children to access free school meals that we use facial recognition technology to authenticate their identification. So the same principle can be interpreted in drastically different ways, depending on whether you take a strict interpretation to the fundamental right or a loose interpretation to the fundamental right. And so I think this is maybe a risk of putting too much store also in these principles. They're only as strong or as protective as the data protection regulator or the court who's applying them deems fit. I'll leave it there.
Thank you, Orla. Carolina?
So many thanks, and I think I will echo a lot of what Orla just said. I have to make a first very short disclaimer. This panel for me is a bit of a return to my roots because I met data protection law thanks to Neil Richards' classes. So I have to say that just to clear that out, as Neil cleared out that he works with Woody all the time. Yeah, I was mentioning that I will probably echo some of what Orla was saying because I also would like to start from something that Woody and Neil wrote about the promise of the internet being human flourishing rather than more relevant ads. And I think this is indeed also one of the things that the EU legislator had in mind when preparing and issuing the GDPR. So protecting the fundamental rights of people in the understanding that personal data should be designed to serve mankind. And I think this kind of contributes also to that discussion on the soul of the GDPR. I would like to focus today on how the principles in Article 5, and in particular, the principle of fairness, can be somehow interpreted also as being akin to a duty of loyalty to some extent, in that the content of the principle of fairness, as interpreted by the EDPB in particular, can include some of the concepts that Woody was mentioning earlier about loyalty. In particular, the EDPB defines the principle of fairness as a requirement that personal data shouldn't be processed in a way that is unjustifiably detrimental, unlawfully discriminatory, unexpected, or misleading to the data subject. So this is a very powerful definition. The EDPB also says that this principle has an umbrella function due to its link to many of the provisions in the GDPR. And in the guidance of the EDPB, we also can find some key elements that would be needed for controllers to implement fairness in practice. And I will just mention a few of them that are particularly relevant for this discussion. One of them being correspondence of the processing with the reasonable expectations of the data subject. And I find this to be very important also because it kind of allows to remedy in a way the excesses arising from treating users as economic actors able to make perfect choices, but it can allow to treat them as human beings placed in a certain situation and with expectations that need to be reasonable on the basis of the situation itself. Another key element of fairness is non-exploitation of the needs or vulnerabilities of data subjects. Another one is pursuing the objective of power balance, and this again echoes what Woody was saying at the beginning. No deception of data subjects. And another one that is very interesting is ethical processing. So the need for the controller to see the processing's wider impact on individual rights and dignity. We have also some practical examples, again, coming from the work of the EDPB on the application of the fairness principle. On one hand, we have the guidelines on deceptive design patterns in social media interfaces, which go through a number of what we call dark patterns in interfaces, and such as, for example, burying the information in a maze and not allowing the user to find privacy choices and so on. And all of these are described as having the principle of fairness as the starting point for evaluating whether they're compliant with GDPR. And so these practices would be on a case-by-case analysis, but conflicting with the principle of fairness. We also have, as Orla was mentioning, also the binding decisions adopted at the end of 2022, where in a dispute among concerned supervisory authorities, the EDPB instructed the LSA to add an infringement of the principle of fairness. in cases where breaches of lawfulness and transparency were already established. This is very interesting because the main reasons for this finding by the ADPB in terms of the breach of fairness were, first of all, the power imbalance, because in the cases which were concerning Facebook, Instagram, and WhatsApp, users were not aware of the ways and extent to which their personal data was being processed, and a fair balance of power in the relationship between the controller and the data subject hadn't been appropriately found in the case at stake. And then the other main element on which the ADPB relied was the misleading manner in which the services were presented, so much so that it wasn't clear to the user whether the legal basis used by the controller was consent or performance of contract. And this also brings us to the close link that fairness has with the principle of lawfulness and transparency. It's true that we can also look at the directive and see that transparency wasn't mentioned per se. There were just lawfulness and fairness. So at the time, I mean, of course, there were duties to inform, but it wasn't mentioned among the principles alongside the other two. And so transparency was kind of read within fairness to some extent. So this kind of maybe caused a bit of a merging between the two, but then now the GDPR spells out the three of them, which allows us to give an independent meaning to each one of them and some autonomy. Although, of course, the three of them are closely linked. And one last point that I would like to make before wrapping up is that the principle of fairness is a provision in the GDPR. It's a principle, but it's a provision that can be breached in itself, even where other obligations are complied with and other principles are respected. So this, to me, kind of sounds like what Woody and Neil were writing about loyalty not being waivable, because it's true that under the GDPR, even if there's a valid legal basis, for instance, or, for example, if there's consent or another legal basis for what matters, this doesn't negate or diminish the obligation for the controller to engage in fair processing, and so the obligation to comply with the principle of fairness. And this applies to lawfulness, but it also applies to transparency. The fact that the processing was transparent doesn't mean per se that the processing was also fair. And so this really gives a lot of power to this principle. And again, as Orla was mentioning, it's something that can be further explored and given attention to, also by controllers, I would say, because it's a level of care and protection to be afforded to data subjects in the processing of personal data that can also allow to build trust in these relationships, and one that, as I was saying, can allow to avoid treating users as purely economic actors that we need to bury in very long privacy notices, but actually treat them as human beings. This is it. Thank you.
Thank you. David, and I'd like to apologize for the background noise, and thank you for your endurance in dealing with having to filter out what sounds like a bar. Going on, but I promise you they're not serving drinks yet. So, David.
Oh gosh, well, I wonder what it will be like after that. But anyway, so yes, it's a great pleasure to be here. I'm going to be offering some, hopefully not too random thoughts, but maybe more random even. You know, we're moving along to maybe some more general thoughts. Including on UK data protection reform, but picking up on Woody and Neil's really interesting work on data loyalty, in particular your Washington University Law Review tome in 2021. So, I mean, one thing which is emphasized in that article, which I think is certainly true from a US perspective, but probably isn't so true from a European perspective, is the idea that data protection has strongly prioritized notice and consent. I mean, the document which I see as the kind of foundational document of European data protection, the Data Protection Convention from the Council of Europe in 1981. I don't know why they always call it Convention 108, because that would be like calling the European Convention on Human Rights Convention 5. But it's the Data Protection Convention. Does not mention notice or consent at all. Neither does its explanatory report. I did check that. What it does mention, and is emphasized in its explanatory report, is responsibility. The responsibility of data users, that was the terminology then, to provide protection. And what does it mean by protection? Well, it is really what became those Article 5 standards of data quality, data use standards, data minimization, adequacy, accuracy, and yes, of course, that lodestar, albeit very amorphous, of fairness. Transparency was always there, at least subject access. And the GDPR, I have to admit, massively increased transparency as a duty. Look at Article 12, 13, and 14. Look at the roughly 17 bits of information, depending how you count it, which apparently has to be provided in all and every circumstance of any ordinary direct collection of data. And yes, the GDPR has a recital on control. But that's a little bit different. I'll come back to that. I want to make some brief remarks on consent. So the formal role of consent dates from the directive era, particularly in the context of sensitive personal data at a pan-European level. And what the GDPR tries to do here, I think, is try and make sure that any consent is genuinely a strong consent. It's freely given. It's easily withdrawable. It's very specific and granular. And actually, I think that that strong consent potentially does still have quite a powerful role to play as an addition to that responsibility standards. And I am also intrigued by, could some of the exceptions to that be based on a very strong data loyalty guarantee? But nevertheless, it gets to your paper actually between two different senses of loyalty. Loyalty as instruction, which would be the consent, and loyalty as best interests, which would be a sort of alternative safeguard. But all of this depends on strong enforcement, which I know is mentioned in Neil Woody's work, but I think has been sorely lacking at a UK level anyway, and it's something I will come back to. I know time is pressing. So GDPR boilerplate has not been helpful. There's a huge amount in it. I mentioned transparency, many of the integrity rules around data processor agreements. There's really no contextuality. The control often is unrealistic. The one-size-fits-all, which often is what the GDPR defaults to, is unhelpful. And what I found most interesting in Neil and Woody's analysis was trying to refocus the discussion onto thresholds, of trying to have specific rules for specific circumstances. So if trust is invited, if the person is vulnerable, and if they are in a mediated environment, then to have very onerous controls, including potentially transparency controls, fine. But if you're trying to make an appointment with your hairdresser or something like that for a trivial operation, let's be realistic. GDPR has not provided the appropriate standard in these sorts of cases, and that is a problem. And it's a problem with the rule of law. The GDPR only made some nods to this kind of idea of thresholds. Yes, we have the idea of policies as proportionate. We have data protection impact assessments when there is a likely high risk, which actually looks a little bit more like the thresholds. And what that adds is aren't so much the duties, but it is the documentation, that the careful assessment should be documented, the proportionality should be documented, the compliance should be documented. But there is a very strong sense that the GDPR has sought to throw everything at the situation. And alongside poor enforcement, at least in some jurisdictions, that the danger is that leads to privacy theatre. It leads to the box-ticking exercise where, there's such an amorphous range of things someone could be called upon. As long as they can show some kind of relationship with a fair proportion of them, they can perform this theatre, and actually that is not serving privacy well. I don't know whether Neil wants me to make some brief remarks about the codes here, but there's a danger that the codes in the UK context actually add further confusion to the mix and further ways in which various forms of theatre can be performed. I won't go into the children's code at this stage, although I note that the best interests are only a primary consideration, which is quite opaque language actually anyway, but maybe it has to be. But then why don't we just stick with the GDPR at that kind of big tech level, because there are huge issues there. Why do we try and complicate it with codes? UK reform, very, very briefly. What is it doing, the Data Protection and Digital Information Bill? Well, I'm afraid the idea of gradations, the idea of thresholds is really not there. On the substance, actually, I would say that there's very little substantive change. I mean, most of the changes on the bill are on the margins. The hard wiring of the GDPR remains in place. And I do actually think that some of that hard wiring is problematic. It doesn't have this contextuality that I think is so necessary. There is a danger that things like recognized legitimate interests and recognized as always compatible processing, which is a new concept introduced in the bill, is somewhat dangerous as a principle, because it means that all these issues we've been talking about, like proportionality, fairness, let alone data loyalty, would appear to be absent at that stage. And the list is quite low at the moment, but they are things like any activity to detect crime. And we're not talking serious crime here. We're talking that, there are probably thousands of offences, including ones which are punishable by a small fine, not necessarily considered something where any form of processing would really be acceptable. And yet we're told this will anything can be repurposed in any context, in any situation, and it will be legitimate. And that's somewhat concerning. We're left with the word that it should still be fair processing, but really, how much is a judge going to rely on that, let alone a regulator, rely on that word? I feel I'm running out of time. Integrity duties, there is a reduction in some boilerplate around things like documentation, but data protection impact assessments are narrowed not to focus on legality per se or legal compliance per se, just necessity and risks. And data protection officers become senior responsible officers who are likely to be much more clued into the objectives of the organisation rather than having that kind of semi-autonomous relationship. There's a danger that internally there may be some loss of rigour in terms of this careful analysis. Now, that wouldn't be so much of a problem if we had a good external system of rigour, which I think is so desperately needed if we are going to have these kind of careful balancing, let alone a best interests analysis. And that's even more worrying. So the context here is that in the last reported period, 2020 to 21, last annual report, our regulator, the Information Commission's Office, issued not a single GDPR enforcement notice, secured no criminal prosecutions whatsoever, and gave out just 4 fines, all to do with data security. So far, far away from these concerns. I know there's been a little bit of a move back more recently, but nevertheless, for a whole year, totaling £183,000 in total, all of the fines. That doesn't provide a signal, that doesn't provide an incentive, in my opinion, to be thinking along the sort of lines that we're talking about. And yet, the bill would provide no effective redress or systematic oversight in relation to that, would place new responsibilities for promoting trust and confidence, for promoting innovation, for promoting competition, which would seem to be further decentering the idea that this regulator is here to uphold core data protection rights, and would let the Secretary of State set strategic priorities, which the Information Commissioner would have to have regard. So more contextuality, more gradations, important, related to this debate, but we're not really seeing it in data protection reform. I think we do need that. And otherwise, we need strong enforcement and working with, and this picks up on Orla's point, I think, working with what we have in the existing law. Thank you.
Thank you, David, and thank you to all of the panelists. I think I really do want to get to audience questions, and we have 8 minutes until we're going to open that up. But I'm curious, mindful that we have 4 law professors in addition to myself, and this is a dangerous thing to try and do. I'm curious if any of the panelists have reactions, strong reactions to things that they have heard.
I'll jump in and just say thank you all so much for such a wonderful and thoughtful exploration of loyalty and the future of data protection. This did exactly what I was hoping we would get into, which is surfacing some of the values of data protection law in the EU and also in the United States, I think, maybe by proxy. And I strongly agree that so much of this discussion is going to depend upon having meaningful enforcement mechanisms, and you have to be very careful when wading into this territory because if you leave it undefined, there's going to be room for incredible shenanigans. And it could be watered down to the point of it being nothing. The only other thing that I'll throw out there for potential discussion, or just to complicate the problem, is that when I look at a lot of the values, fundamental human rights values that are relevant for the GDPR and in general in the EU, the concept of balancing comes up a lot. The idea that we should balance free speech rights with privacy rights, informational self-determination. And I'll only add one potential complicating factor with data loyalty, which is in the strongest version that Neil and I have proposed, and correct me if I'm wrong on this, it's not just balancing that we would be calling for. We're calling for a prioritization of the trusting party, so that it wouldn't be sort of an equal balancing, all things being considered. It would be explicitly favoring protecting trust in that relationship at the expense of other values. Right, yeah, Neil wanted me to add this. Putting the protection in data protection. So I'll just throw that out there as a potential complicating.
That was an excellent point, particularly the final bit. Other reactions or thoughts? I'm happy to throw questions out, but I know there was a lot there to chew on. Orla, I see you moving your head vigorously.
No, maybe just to react to what Woody said. So I've been thinking about this. So in preparing, I've been thinking about, well, what can we achieve under the existing data protection framework, and actually what's legally permissible? You know, if we were to introduce a duty of data loyalty, would it be permissible under the fundamental rights framework to kind of default in favor of the interests of the data subject over others? And I didn't mention it because I'm not so sure that that's possible, because precisely you're in the realm of balancing. The only kind of maybe counterpoint I would put is that if we go back to the debates about the meaning of an independent right to data protection as opposed to, let's say, privacy, a lot of the discussion there has been around the idea of individual control over personal data. And I think previously I've always argued that the idea of individual control over personal data is not to say that individuals absolutely control their data, because clearly that is A, not like what happens in the real world, and B, not normatively desirable, because we have lots of situations in the GDPR where we override that individual control over personal data, like where there's a law that states that there must be data processing. But rather, I think it could serve that purpose of kind of defaulting things in situations of ambiguity about where the default lies. It would default in favor of the data subjects, and that again would get you to that kind of same starting point as the duty of data loyalty. So I think that's one way how you could argue that kind of defaulting in favor of individuals as opposed to, let's say, large corporations that process personal data is in fact still compatible with the kind of fundamental rights approach to data protection.
And David?
Yeah, I mean, I'll just add a few more points. I mean, you can see
I'm shocked, David.
I will try and keep to only a few. If you look at, say, the Court of Justice's jurisprudence, most famously Google Spain, this statement, which was much misunderstood, actually, about a prioritization, that the interests of Google, which were judged purely economic, would never override the interests of the individual in relation to a de-indexing, and even the interests of internet users. They should have said freedom of expression, to be fair, at this point, wouldn't override it as a general rule. They were talking about a specific context where there was a significant and additional effect on fundamental rights. And so if what Woody and Neil are getting at are situations where there is significant rights impact, and largely it's economic on the other side, there already would, as a general rule, be a prioritization. I mean, best interest is odd because it would almost seem to prohibit a lot of what might not be directly serving the interests of the individual. I mean, but that fundamental rights jurisprudence should get into the territory of a prioritization. And then, of course, we have two other things I'll briefly mention. Once someone objects, which should, of course, be quite easy, any legitimate interest needs to become a compelling legitimate interest if it is going to be if processing is going to continue. And then, of course, a lot of what we're talking about is Article 9 territory, so it's sensitive data territory. And there the starting point is a prohibition on processing, which can only be lifted in very narrowly defined circumstances. And so that is actually, if anything, more onerous, because you need to show a public interest on processing, unless you're relying on consent or the manifestly made public. But note that manifestly made public is in the present tense, is being manifestly made public, although we don't have jurisprudence on that point. And consent can be prohibited by states in specific contexts.
And Claudia wishes to add something.
Yeah, just sort of taking a meta point, both of what Orla and David just said, just sort of illustrate to me that what you're really trying to do is this constitutional workaround, right? So if you want to create an override in your strongest version, then that, to me, getting out of the proportionality, that really does sound like a right as Trump type approach, right? And so what I find interesting there is that even absent this horizontal application proportionality type story, you're now correcting with a non-constitutional lever that takes you beyond what we would sort of consider as, within a constitutional framework, because you do have the economic interest on the other side. You also do have potentially a speech interest on the other side. By kind of calibrating your duty of loyalty in this very strong sense, right? You're sort of, from the European perspective, perhaps overshooting the target. And so I just wanted to kind of, pull out this framework again for kind of a meta perspective.
So I wanted to ask a question about the comparative aspect of this. One of the things that I've really enjoyed about this conversation is it sort of seemed, we have a lot of people from multiple countries. We have individuals from multiple countries on our panel. So I think we have a sort of comparatively inclined group to begin with. But one thing I've really appreciated about this discussion are the ways in which we've been able to talk about the US and Europe in particular, in a way that is nuanced and respectful and not essentialized. So I think it was Claudia made a reference to this idea. Often in American legal discussions, we talk about Europe as if it is this essential monolithic thing in a very archaic way. It reminds me of the lyric from the LCD Sound System song North American Scum, where they refer to Europe as the place where the buildings are old and they have lots of mimes. It's a very reductionist and false view, or maybe deeply incomplete view, I should probably say, of how things are. And I think we've been able to transcend that. I'm not going to ask my panelists this question because I want to hear from our audience. But I think it is perhaps as we sort of continue our conversation with the larger group, worth thinking about, in the comparative sense, the idea of different tools for different systems, right? That Woody and I have been pretty critical of what we call a US GDPR or a GDPR light, on the basis that the US system would not be receptive to a carbon copy implementation of the GDPR lacking the foundation of Article 7 and Article 8. What you would get will be something that is weak and terrible. And actually, as US states are individually starting to pass their own versions of the GDPR, most of the ones that have been passed, I think, speaking for myself, would fall under the definition of weak and also terrible. But it was interesting thinking about loyalty as a U.S. response to something like Article 5 or an equivalence to Article 5, or even the implicit notions of loyalty and power imbalances, or to use Gian Claudio Malgieri's concept from his new book, vulnerability in data protection. And then this idea, to take one final reference from European data protection law and the Schrems cases, of essential equivalence, right? Maybe we're not all that far apart from a value sense, even if we might need to use different strategies in different legal systems to get to something that is equivalent or essentially equivalent, avoiding the natural cross-border implications of that, but sort of equivalent on its own terms in terms of ethics and principles. But I want to open it up to where we are 4.5 law professors. We can talk all day. But other questions from the audience? Marty.
So I'm Marty Abrams, and
Marty, could you speak into the microphone?
I can surely speak in the mic. I'm Marty Abrams. I lead the EIAF. I am not a lawyer. I'm an anthropologist. I've been in the privacy area for 34 years, and I have two questions. One, as you for our European colleagues, as you ground this concept of a responsibility to the parties to whom the data pertains, and those parties that are going to be impacted by the processing of data, because it's not just that part, it's a broader group of people. Is it useful to go back to Recital 4 and the concept, the breadth of Recital 4, to help interpret Article 5 and interpret this concept of having a responsibility to be fair to a full range of rights that are impacted from the Charter that are impacted by privacy? And for my American colleagues, if you look at the final rules from Colorado, specifically Rule 8, and I'm not expecting anybody else to have read Rule 8, which it requires an assessment against a full range of adverse processing impacts, and not just the data subject, but groups of people and society as a whole. Is that not reaching more towards this concept of a duty of loyalty than what you would find in the federal legislation?
All right. The Europeans want to handle Recital 4, to serve mankind?
Well, yeah, we were pulling up Recital 4 to make sure that we were looking at the same text. But on this concept, what I wanted to mention is maybe the element of fairness that ADPB has indicated as ethical processing, so looking at the broader impact. And this is maybe something that indeed can help to kind of see in the concept of fairness also this aspect of designed to serve mankind, as I was mentioning also at the very beginning. This would be it. And maybe the other point that I can make, although it's not linked to the GDPR, but that I found to be interesting when preparing my thoughts for this panel, would be connected to something that is in the Digital Services Act. So the need for providers to identify, assess, and mitigate risks arising from their services, including possible negative effects for fundamental rights. So not just privacy, but also dignity, freedom of expression, non-discrimination, respect of the rights of the child, consumer protection, civic discourse, and others. And so I think that also these other pieces of legislation can kind of speak in the direction of having a broader look at the impact of the activity in the digital world, rather than simply at the impact on the specific person or the specific instance.
Yeah, if I might just add to that, in this recent kind of suite of EDPB decisions vis-a-vis Meta, one thing I thought that was quite interesting was that the European Data Protection Board emphasised in kind of requiring the Irish Supervisory Authority to add into its decision the duty of fairness. It emphasised that the way in which the law was applied in this circumstances would have an impact not simply on Meta users, but also on individuals across the EU. And so you could see there that the way in which the law was being interpreted was kind of in a very kind of general sense, which kind of, I think, acts as a really strong counterpoint to those who argue, well, the GDPR is extremely individualistic. It can only kind of cater for individual circumstances or all that's taken into account. To here you see kind of a robust interpretation of the law being justified on the basis of kind of general impact. Now, it doesn't go on to talk about serving mankind or anything else, but I think that's quite significant.
Let me offer a quick response, because Woody was furiously taking notes on the Article 4 question when you mentioned Colorado. For either Europeans or people who are not closely following the rulemaking process in Colorado under one of the 5 or 6 U.S. state privacy acts. The Colorado law is interesting because it did have the state privacy law, which is FIT-based and consent-based and follows the pattern here. It did have like the California law, a rulemaking procedure where the agency, or I guess the Attorney General's office probably in Colorado, but where the bureaucracy is able to create regulations, the agency, to supplement the rule. And there is a very interesting language, as Marty pointed out, in the Colorado regulation, so not in the statute, but which will have the force of law, doing something like, as part of your determination for a legitimate processing, you have to take the interests of the data subject and society as a whole into account. And the question was, is this a duty of loyalty in disguise? And I think the answer is probably yes. And it has an interesting drafting history, but I don't want to disclose too much, but law professors were involved in that one. And I think it does show not just the influence of ideas, but it goes to something that Orla said in her opening remarks about these principles are only as good as their enforcement, but also the ability of regulators and agency officials and courts to take them seriously and to give them meaning. And I think it's an important thing to say on a panel which is taking place behind a big white sign that says ideas that drive our digital world. And I think this idea of the quest for new ideas and animating principles and commonalities and similarities is a really important thing that we shouldn't lose sight of as global data protection lawyers and global privacy professionals, because it's easy to get bogged down in the latest draft of the latest draft statute, and it's important to look at the big picture and to ask what could be better once in a while as well.
May I ask a question?
Yes, please.
Yeah, thank you for this magnific debate.
Could you? I'm sorry. Could you move a little closer to the microphone?
Okay. Now?
That's perfect.
Okay,
yeah.
perfect. So I was triggered by this comment that you made about what is the soul of the European Union, and to me it seems that we have drunk a lot about German idealism, and we have configured a fundamental rights framework that is highly ethically, deontologically based, where fundamental rights, they are indivisible constructs. In some occasions, they are also inviolable constructs, like human dignity. And I think that data protection law also drinks a lot from these concepts, right? It has a very strong human rights-based approach. Now, there was also this comment about Professor Erdos, where he said that we also count with data protection impact assessments in Article 35 of the regulation. To me, this is a tool that has a totally different rationale. It drinks from utilitarianism and the fact that you can deconstruct rights or decompose it, and we give this power to data controllers to be in charge of making this assessment. So I was thinking, if by the introduction of DPIAs, we in the European Union have lost that fundamental rights essence or soul that we have, and whether we can learn something about this approach of loyalty that they are being postulating here.
Yeah, thank you for that. I really appreciate that. And that's something that I would actually agree with you, that one of the reasons that loyalty, I think, is attractive, and Marty's question about are there loyalty duties sort of hiding in disguise, I think is, as long as we can get to the end point where we prioritize vulnerable parties on the bad end of power disparities, then you can see that as a way to stop the drift that I see happening in things like impact assessments, where they often sort of devolve into checklist exercises that seem sort of unattached to what we might deem as critical human values. And at least the way that Neil and I see it is loyalty is a way to try to keep that on track and to refine that. I don't know, Neil, if that's generally what you would say.
If I could add a further comment on TPIAs, I think it's quite a multifaceted article because on the one hand, you have a focus on risks, and risks could be misinterpreted to say if you have a lot of benefits and actually a definable right is violated, that's fine, which I don't think is actually what it's saying. It's more saying that they are some elements or like legitimate interest analysis which require risks to the individuals to be balanced against other things in order to see if a right has or hasn't been violated in the first place. But I do worry that the other aspect, which is separate from that actually, maybe it is misnamed, is that you've got to, in your impact assessment, show compliance with the law, which actually takes you through in a documented way through to that fundamental rights approach anyway. That aspect is the bit that is being dropped in the UK Act. And so, yes, I do think there is some danger that it could become a little bit more like Woody's analysis, even if that's not actually what it's saying. That might be how it's understood.
One of the dangers of coming to CPDP is given the richness of the people in the audience, you can sometimes mention people's work and you don't see that they're sitting there. And so we have a minute left, but I would be remiss if I didn't give John Claudio an opportunity to ask a very brief question.
I'm sorry that we don't have time, but just to say, connecting the two questions before, maybe in the cocktail we can discuss what do you think about fairness as being a scalable concept from loyalty in contract law, where it's just do no harm, to if you are a platform that enables my fundamental rights, your fairness become a duty, a positive duty to enforce and to make sure that your fundamental rights are respected. Is fairness a good scalable concept for that, or loyalty as we wish? But it's a too big question, so I think we will leave for...
And just, thank you for the question, Claudia. And just as he finished his question, my watch said it went from 5:14 to 5:15. And knowing that we are standing, I believe, between you and coffee, or at least between you and another panel, or between the next panel and this panel, please join me in thanking my panelists, and thank you all for coming and for a rich conversation.